right, thank you, Judge Bigler. I do have 3 handouts, and they are also on the website or wherever you go to download them. So if you happen to lose them or forget about them or want to refer to them at some other point, you can still download those. One of them is the criminal jurisdiction chart. We're going to go over that at the conclusion of the criminal jurisdiction section. The other is a map that many of you may find is familiar, showing the tribal jurisdictions, also showing the counties. And I've modified that map to also show the federal districts. And most of you know there are 3 federal districts in Oklahoma: western, northern, and eastern. Sometimes people forget that there's a portion of the Otoe, Missouri jurisdiction in the northern district, or that there is a piece of the Pawnee jurisdiction in the western district, or part of Chickasaw straddles the line as well. So those boundary lines are drawn in there. Sometimes we've had cases that have been on the wrong side of the line, and people have had to figure that out after we go to the maps. I'm going to start out first going through criminal jurisdiction so everyone has a basic understanding. We're going to conclude with some recent cases, some cases that you may have heard about, some cases that are recently decided, and a couple that are pending. All of this relates to criminal law, criminal jurisdiction in Indian country. In addition to that, many of you may or may not know there have been some changes to criminal law in the past few years. There have been some additional amendments to the Major Crimes Act. We've got new jurisdiction that tribes can assert over non-Indians and some federal statutes that a lot of people really don't even know about, several of which are aimed at protecting victims of domestic violence. And that's one of the priorities that we have in our office, is to address domestic violence issues. So we're going to go ahead and start going through this PowerPoint. We'll leave some time for questions. Also, we want to make sure that everybody has a base understanding of criminal jurisdiction. It is very complicated. A lot of times even federal prosecutors think they know something, and sometimes I have to sit and stop and think, okay, we have a non-Indian who's committed a drug crime, and then we have an Indian who's committed a conspiracy, and one of the victims is a non-Indian, and then we have an Indian who's committed a crime that's interstate commerce based, and sometimes we can have a lot of different things going on. And unless you look at each individual, each crime that's taken place, it's hard sometimes to sort that out. And it does get very complicated. So we're going to go ahead and start through that. Of course, criminal jurisdiction is based upon a variety of things. History has played a significant part in determining where we're at. There's my disclaimer. These are my views. These are not any positions of the Department of Justice or the U.S. Attorney's Office. So don't attach this as an exhibit to a brief. Thank you. Why do we examine federal criminal jurisdiction? Well, of course, criminals travel in and out of different jurisdictions, in or out of Indian country. Sometimes we have intel that specifically criminals go to Indian country, particularly casinos, to do drug deals, to launder money, to do other things, with the belief that there's confusion as to who has authority, if somebody Indian or somebody non-Indian, if the tribal police have jurisdiction over them. So they target Indian country to do things, or they set up enterprises in Indian country thinking that they can somehow escape federal law or escape state law. Of course, we don't want Indian country to become a haven for criminal activity, so that's why we all need to be on the same page in understanding and addressing potential crimes. Everybody knows, based upon these 2 cases from the Supreme Court, Indian tribes are domestic dependent nations, and generally are not subject to state law absent a congressional act or absent a congressional enactment or a court decision that has affected that jurisdiction. That's where we start out. Here in Oklahoma and elsewhere, of course, one of the biggest questions is, where does Indian law apply on what properties. And of course, after a lot of the tribes were moved here from as far away as Oregon and New York and the 5 tribes from the southeast, federal policy changed. There was a policy instituted of allotments, which basically was aimed at breaking up reservations, individualizing tribal land holdings, and promoting non-Indian settlement of Indian reservations, not just here, but all throughout the West. So where we started out was a tribally controlled area. We had reservations that were open either by land run or by settlements, negotiations, or sometimes by lotteries. And we had non-Indians move into what were once contiguous land reservation areas. So if we start out with one of the large treaty-based reservations, which we have here, and it's shown on this original, the last original reservation boundaries on this map. We have large contiguous pieces of land that were owned by the tribe, not owned by individual Indians. After land runs and openings, prior to the openings, in most instances, we had individuals who were living at the time whenever the allotment took place, could be anywhere from 1892 to 1906, were assigned individual parcels of land. The bulk of the land in Oklahoma that remains today that is Indian country are those original allotments still held in restricted status or trust status. For the purposes of criminal jurisdiction, it doesn't matter if it's restricted status or trust status, it's still Indian country. We also had other parcels of tribal trust land, and in some instances those were tribal cemeteries, tribal headquarters, tribal buildings. And then we have what's sometimes referred to as the elusive independent Indian community, whatever that is. And we'll define that in just a moment based upon some Supreme Court cases. So when we move forward, we have to understand that allotment didn't just take place here in Oklahoma. As many people know, allotment took place all over the West and ended up, for example, here in, this is Pine Ridge, this is Rosebud. There were portions of Pine Ridge that lost their boundary status, and there are all kinds of allotments over this former area of Pine Ridge. This area of Rosebud, outside of that reservation area, Rosebud used to be this whole area. There are all kinds of allotments over there. A lot of these other reservations up in Montana, you look on Rand McNally, they look like one large piece of land, and they're actually not. If you go to California, the Agua Caliente reservation is a perfect checkerboard. And so as you're driving down this road, you're going on Indian land, off of Indian land, on Indian land, off of Indian land, depending on what side of the road you're on. This is what the Cherokee Nation looked like after the original allotment of land. Of course, the original boundaries were set forth on the map here. The little orange dots are what were the allotments made at the time of prior to 1906. This is what Pine Ridge really looks like. You can see there are all kinds of state land holdings, private land holdings, tribal land holdings, allotments, government land holdings within this checkerboarded area. This is Fort Berthold, which looks very large originally, but actually those are the only areas that are still held in trust status. This is what Cheyenne River looks like. There's a lot of non-Indian land holdings in Cheyenne River. There's a lot of state land and federal land. So that's the first part of what we need to understand to determine tribal jurisdiction is what land is Indian country. And a lot of times, years and years ago, from one of the old guys like me, you see federal legislation that would always say Indian reservation, Indian reservation. Really the proper term to use is Indian country, because Indian country encompasses more than just reservations. Indian country is defined in Title 18 U.S. Code Section 1151, and it has 3 parts, and that's where the special rules apply. The 3 parts are set forth in 1151A, B, and C. 1151A is all lands within formal and informal reservations, or actually it says within reservations, notwithstanding the issuance of any patent. So in other words, if a patent has been granted to a non-Indian landholder or to the state or to somebody else, that doesn't matter. If the boundaries exist, the whole reservation is Indian country. The second part are dependent Indian communities. Dependent Indian communities was a definition that the Supreme Court came up dealing with some of the Pueblo communities in New Mexico. And basically after a Supreme Court case, Native Village of Venati versus Alaska, what the Supreme Court said was in order to have a dependent Indian community, you have to have two things. You have to have federal superintendents over the land, plus the land had to have been set aside for exclusive use and occupancy of Indian people. Now, some of you may remember there were some old decisions. There was this Oklahoma Supreme Court decision involving tribal housing authority, which basically said a tribal housing area could be a dependent Indian community. I don't think that that would hold up anymore in light of that Supreme Court decision. Then the bulk of our cases of criminal jurisdiction that come up in Oklahoma are Indian allotments. And those are the trust allotments, restricted allotments, still held in trust status. It does include roads, right-of-ways going through the allotments. Doesn't matter if it's a state road, it could be I-40 or I-35. Doesn't matter what's on top of the property. It matters what the status of the land is. Okay, so question. Are there Indian reservations in Oklahoma besides Murphy and the Creek Nation? How many say yes? Okay, how many say no? How many don't want to raise their hand? Okay, everybody should know this, okay? If I have a crime at Riverwind Casino, okay, Riverwind is just south of Norman. It's actually in McLean County in Goldsby or part of Newcastle, I think. Would I charge somebody under 18 U.S. Code 1151A, B, or C? C, as an Indian allotment, okay. Is there an individual Indian that owns the riverside, I mean the casino there? Riverwind, sorry. No, because that can't be C, right? That's an individual allotment. If somebody did, they'd be sitting pretty, but I don't think the Chickasaw Nation would put a big facility like that on an individual's land. Okay, is it a dependent Indian community? Well, Riverwind used to be a Burger King and a little truck stop when it first was put in there, and actually didn't go into trust, I don't think, until like late 80s, maybe in the 90s. So it's not a long-standing Indian community either. So it's not, so is it Indian country? I mean, there's gaming going on there, right? So what is it? It's got to be A. It has to be A. It can't be anything other than A. So technically it's a reservation. So every Indian casino right now, unless somebody's got a casino on an allotment, which I don't think there is one, is going to be 1151A. If we go to federal court, we're going to charge a committed a crime in Indian country as defined by 18 U.S. Code section 1151A, which if you go to the statute, it says a reservation. Tribal headquarters. Are those allotments owned by individuals? No. Are they dependent Indian communities? No. They're 1151A reservation lands also. So, there's all kinds of examples of 1151A land. And there's this case here, Oklahoma Tax Commission versus Chickasaw Nation, talking about the term of an informal reservation, this Indian country, USA versus Oklahoma. Formal designation of Indian lands as a reservation is not required for them to have Indian country status. Okay, that's why those tribal trust lands held in trust technically are 1151A informal reservations. Now, they're not a large treaty reservation, they're not established by executive order, but legally They're Indian country under 1151A. And it includes rights of way, like we said, running through the boundaries. Inside the city limits of Lawton. Okay, does anybody know what this green area is? Okay, if you know maps, if you're coming down this, let's say you're coming down this road, you're going through Fort Sill, okay, and then the highway swings this way, and we've got a Comanche Casino right there, we've got a Fort Sill Apache Casino there. Anybody know what this is? That's the old Riverside Indian School. That used to be government land. All of it was returned to the Kiowa, Comanche, and Apache tribes. Okay, all that green area is going to be what? 1151A, B, or C? C is an allotment. No, it's not a dependent community either. Maybe it could have been at one point in time when the school was shut down a long time ago. Again, that's 1151A. Okay, that's technically reservation land. And then you see over here, that little green square there, that's owned by the Comanche Nation. That's where Comanche Nation Games is. And over here, the Fort Sill Apaches have a little piece of land there. That's where their casino is. And then there's some allotments. So there is a lot of 1151A land out in various locations that we have jurisdiction over. Again, dependent communities defined by this Supreme Court case has to be set aside by the federal government, has to have federal superintendents. An example of that we have in the Western District is the Riverside Indian School. Okay, it's government land. Is it Indian country? Is it tribal trust land? No. Is it an allotment? No. But it was set aside for exclusive use of Indians, and there's federal superintendents over the land. It's run by the federal government. They have their own water supply. People live there. Students stay there. And then, of course, the bulk of our land in Oklahoma are these Indian allotments, which has resulted in this checkerboard pattern, depending on the size of the allotments. This is near Carnegie, Oklahoma. If you're traveling from Fort Cobb, this is Highway 9, and then it goes south. This is Wichita, Caddo, Delaware side, and then you come south. These are all Kiowa, Comanche, and Apache allotments. And so you can see, when we have crimes occur, we have to figure out, did the crime happen on this square or on that square? Okay, somebody was stabbed here and they hid the knife across the road. Where is it located? That's how complicated sometimes it gets. That's why we always want to have, where we can, cross-deputization, where we can have a tribal officer have tribal authority, state authority, and federal authority. Or we can have a deputy sheriff have state authority and tribal authority and federal authority, so that we don't lose cases because evidence was collected where somebody was acting outside of the scope of their authority, which you heard about earlier, that Ninth Circuit case. Or we don't want an officer to be sued, be subject to a lawsuit because they arrested somebody or maybe used force or shot somebody and they didn't have any authority to be there. They had no authority whatsoever. We don't want that either. So without reservation boundaries, this is what jurisdiction, most of it looks like in Oklahoma presently. With reservation boundaries, the entire area becomes Indian country. So that is what is at issue presently now in the Murphy case. Okay, so if you have boundaries established, they're still recognized, not erased, then under 18 U.S. Code 1151A, it says all lands within the limits of Indian reservation, notwithstanding the issuance of any patent. That means regardless of who owns the land. So if the boundaries are there, the whole area is Indian country, okay? So that's what it is at issue in the Murphy case. It doesn't really have to do who has jurisdiction over who or anything. It's really a question of the land. What part is Indian country? And as you can see here, what's this big dark area right there? That's the city of Tulsa, okay? Then we have lots of other cities here. So if Murphy stands, if the Supreme Court leaves the 10th Circuit decision in place, the Creek Nation would have jurisdiction over this entire area. All of this would be Indian country. And the federal government would have jurisdiction over this entire area. All of this would be Indian country. Okay, for criminal jurisdiction, how would that have an impact? Would the state of Oklahoma have criminal jurisdiction over traffic offenses committed by Indians in downtown Tulsa? No. Okay. If we had an Indian who was committing a drug offense, would they have? Would the state have jurisdiction anywhere within those boundaries? No. If we had an Indian commit a crime against another Indian or a non-Indian within that area, would the state of Oklahoma have jurisdiction? No. If a non-Indian committed a crime against an Indian, would the state of Oklahoma have jurisdiction over a non-Indian committing a crime against an Indian within that area? No. Okay? We'll explain why that is. So that's the implication of that decision. And of course, I'm not expressing an opinion in one way or another. That's all been briefed in multiple briefs. And ultimately, the Supreme Court's going to decide that in the Murphy case. I think there's somebody on the panel tomorrow going to be talking about that specifically. The other issue is civil jurisdiction, because Indian country also defines the area where tribes can assert their civil jurisdiction. And a lot of litigation that's going on elsewhere in the country has to do with what authority does the tribe have civilly over these areas where they're non-Indians within a reservation boundary. Okay. Another question to determine criminal jurisdictions: who is Indian? Okay. We have to do this in every one of our cases. This is showing where Indians are located. You can see Oklahoma stands out there. As most of you know, each tribe has its own definition of who's an Indian. Sometimes my own tribe, I'm Kiowa, you have to be a quarter. Some tribes take descendancy, like the 5 tribes. You have to find somebody on the Dawes roll. Some tribes are an eighth, like Fort Sill Apache. Some tribes take blood from other tribes and will boost you up. So if you're like a quarter Turtle Mountain Chippewa and a quarter Lakota, they would count you as, or I mean, an eighth Turtle Mountain Chippewa and an eighth Lakota, they would count you as a quarter. Why is that important? Well, all of our criminal law is based upon determining who's Indian and who isn't. And we have to look at both the defendant and the victim in order to figure out if it's a tribal case, state case, or federal case. So, what is the test? You have to be an Indian for the purpose of federal criminal law. You have to have 2 things. You have to have some Indian blood, okay? Just any amount of Indian blood, plus some government has to say, yes, you're an Indian. How would you prove that somebody's an Indian? How would you prove blood first? CDIB card, or if the tribe requires blood for membership. What else would you, as a federal prosecutor, I need some proof. What would I go to court with? What would I show the jury?
Citizenship card.
I heard card?
Your citizenship card.
Citizenship card, okay, so membership. Some government has said, yes, you're an Indian. And what government would that be? Whatever tribe you're enrolled with. Could be Cherokee Nation, could be the Osage tribe. Some government has said you're an Indian, okay? So you have to have blood, and you have to have some government saying that you're an Indian. Could you have somebody who has tribal membership and no Indian blood? Freedmen? Yes, correct. Seminole Nation freedmen are tribal members, but they don't have Indian blood. Would they be Indians for the purposes of criminal jurisdiction federally? No, because we need both of those things. On some instances, we could prove somebody is also an Indian if they have Indian blood, and the federal government has said, we recognize you as an Indian. Let's say somebody's an eighth of 4 different tribes, they're half Indian, but they're not enough to be enrolled in any particular tribe. Would they be eligible for IHS services, Indian Health Service? Probably, somebody who's half. And so there have been some occasions where somebody doesn't have tribal membership, but we can still prove they're Indian because the federal government has said they're Indian. So now we know the status of the land, where does Indian country exist, and what is the definition of it. We know the status of the person, if they're Indian or non-Indian, and then we have to know the status of the crime. Is it a misdemeanor or a felony? Because different jurisdictions have different authority. This used to be the rule. In tribal court, tribe only had jurisdiction over Indians and only had misdemeanor jurisdiction, and it was that way for quite some time, at least since 1978. After the Oliphant case, the Supreme Court said, tribe, you have no jurisdiction over non-Indians. Okay. Now, does anybody know what TLOA is? Tribal Law and Order Act, and VAWA, Violence Against Women Act. Okay, both of those acts have changed that and have granted authority or recognized authority that tribes have to impose felony penalties and also to have jurisdiction over non-Indians in certain circumstances. So this used to be the matrix as to when a tribe had jurisdiction over an Indian, when an Indian commits a victimless crime, over an Indian when the victim is a non-Indian, and over an Indian when the victim is an Indian. Okay. After VAWA, now the tribe has jurisdiction over non-Indians for certain crimes, not non-Indian versus non-Indian crimes, but non-Indian versus Indian crimes. When, does anybody know what SDVCJ means? Stands for? That's a Special Domestic Violence Criminal Jurisdiction, okay? And that comes from ICRA. And ICRA is another, the Indian Civil Rights Act. So if you go to ICRA, you'll find, I don't know how to say that, Special Domestic Violence Jurisdiction, okay. And originally, tribes could only impose misdemeanor penalties after TLOA, the Tribal Law and Order Act. Tribes can also impose felony penalties up to 3 years, or you can stack them up to 9 and have a maximum penalty of $15,000 rather than $5,000. Okay, now, where does the state have jurisdiction, even within Indian country, when there's no Indian involved? Okay, so if you're trying to figure this out, no Indian involved within the boundaries of the Creek Nation, if it's recognized. No Indian involved on an allotment. No Indian involved out in the middle of Navajo. Would the federal government have jurisdiction over a non-Indian versus non-Indian murder in Window Rock, Arizona on the Navajo Nation? So he said no. Very good. Is there any Indian involved? No. So non-Indian versus non-Indian crimes, even on Indian country, no federal jurisdiction. Would the tribe have jurisdiction? No, because it's a non-Indian and it's not a special domestic violence situation. A lot of states don't recognize, state authorities don't recognize, and that's one of the biggest problems we have in some of our jurisdictions where the states say, it's at the casino. We have a drunken, disorderly non-Indian at the bar, let the tribal police deal with it. Can the tribal police deal with it? Absent proselytization. No, they can't, because there's no Indian involved if you have a drunken, disorderly non-Indian. Okay, I'm going to zip through this. The other thing to keep in mind is federal jurisdiction is not just based upon the land. We also have federal jurisdiction in other instances based upon the Commerce Clause. When we have somebody crossing into or out of different states, or into and out of the United States. If we have foreign commerce, interstate commerce, or sometimes crossing into or out of Indian country. The other way we have jurisdiction sometimes is if there's a federal interest involved. If we have federal property that's stolen, if my government laptop is sitting over there and that gentleman in the black hat steals it, knowing it's a federal government laptop, that's a federal crime also. If somebody assaults me in the parking lot and says, you know, you prosecuted my cousin and I'm going to get you, that would be a federal crime because I'm a federal officer and they're assaulting me because of that purpose. So that's one thing to keep in mind as well. Not just Indian country jurisdiction do we get into federal court, but also based upon interstate commerce or federal interest. Now, our two major acts that we rely upon to get into federal court to prosecute people on the land-based crimes coming out of Indian country are the Major Crimes Act and the General Crimes Act. Major Crimes Act is an old act that was passed in the 1880s, and it's been amended. I think I went to law school back in the day. I think it was like, well, the 12 major crimes. You know, there's more than 12 now. There's probably about 50 or more if you look at each one of these. To update you, there have been some additions made to the Major Crimes Act that a lot of people don't even really realize have happened. Okay, of course we have the traditional ones: murder, manslaughter, kidnapping, maiming, a felony under Chapter 109A, which are sexual abuse offenses, both child sexual abuse, adult sexual assault, incest, assault with intent to commit murder. Then this is a new one that we didn't have, at least when I started prosecuting. Assault with intent to commit any felony. That's pretty broad. That's a new Major Crime Act crime. We have assault with a dangerous weapon, assault resulting in serious bodily injury. This is another new one, which is assault resulting in substantial bodily injury to a spouse, intimate partner, dating partner, or an individual under 16. So that's a new one. A lot of people don't know about. We can use that in the domestic violence arena. Assault of a child under 16. Felony child abuse. We didn't have felony child abuse for many, many years. I think that was added. I think I was one of the first ones to charge that in 2005 when that came in. We've got these old ones: arson, burglary, robbery, theft. And this is another new one that came out of a law amendment, which is assault of a spouse, intimate, or dating partner by strangulation or suffocation. That's another new one that we have. I'm going to zip ahead a little bit. So this kind of summarizes where we have state jurisdiction, tribal jurisdiction, federal jurisdiction. Of course, the tribe is going to be prosecuting Indians versus non-Indians and Indians versus Indians. The way the Major Crimes is set up, Major Crimes Act, is that's going to be Indian versus Indian. Only major crimes can be prosecuted federally. If it's not in that list of crimes that I told you about, we can't prosecute it if it's Indian versus Indian. That has to be handled by a tribal court. We can also prosecute an Indian versus non-Indian or a non-Indian versus Indian under the General Crimes Act. And then again, state and locals prosecute non-Indians versus non-Indians. This 25 U.S. Code Section 1304, which was part of AWA in 2013, created a special DV jurisdiction, but it's a very narrow jurisdiction. Congress only gave tribes a thin slice of jurisdiction over non-Indians. If a tribe, and this is based upon tribal law, okay? So the tribe has to pass its own DV codes to prosecute a non-Indian. This is not having anything to do with federal authority or federal prosecution. The tribe can prosecute somebody. However, a case can be dismissed if the victim, if there's insufficient ties to the tribe. If the prosecuting tribe fails to prove that the defendant or the victim reside in Indian country or employed in Indian country, was their spouse, intimate partner of a member of a tribe, then the tribe is not going to have criminal jurisdiction authority. Also, the tribe is required to comply with the U.S. Constitution in connection with these crimes in order to exercise this authority. What does that boil down to? Right to jury trial, defense attorneys for persons accused. So after that amendment, we now have the non-Indian versus Indian addition to tribal jurisdiction in those domestic violence cases. Victimless crimes, again, state and locals have jurisdiction over non-Indians. The tribe and the federal government can have jurisdiction over Indians. The federal domestic violence laws primarily are based upon interstate commerce. So then there's a whole permutation of different variations of federal domestic violence laws. There's probably about maybe 20 different ones. And they have to depending on the severity, if there's interstate commerce, if there's interstate stalking, if there's injury, then we look at all of those factors to come up with a determination of whether or not we can prosecute somebody under VAWA. So actually the federal domestic violence laws are a little bit hard to prosecute because in many instances we have to have 5 or 6 things all come together in order to prosecute them. Now, one thing that we can do is use the federal government's authority to prosecute gun laws, which involves interstate commerce of guns, to go after individuals who commit domestic violence crimes and also possess a gun. For example, I'm going to jump ahead here. We already talked about those new crimes. Let's look at this VAWA. Again, how many has the Creek Nation enacted VAWA-based criminal offenses? Anybody? Good. Okay. Have any other tribes done that here in Oklahoma? Seminole? What about Chickasaw? And I know it's not in the CF, I don't believe anything's in the CFR court tribes. Chickasaw? Okay. And again, that's limited. It involves domestic violence crimes, dating violence, and criminal violations of protection orders. It's not going to cover offenses committed outside of any country. It's not going to cover offenses between non-Indians or strangers. They have to be intimate partners. And again, crimes involving people with lack of sufficient ties to the tribe, or not working at the casino, or living in the tribal jurisdiction are not going to be covered. This is a federal law that a lot of people don't know about, that I've used this, and that's where you have somebody's, basically it's like a third strike domestic violence. So if we've had somebody who's been convicted of 2 other domestic violence offenses, state or federal or tribal, then we can come at them federally. So let's say we have somebody committed a domestic violence offense in the state and was convicted, and the second one in the state was convicted, and then commits a third one on Indian country. We could charge somebody with a felony crime based upon this habitual offender offense. Now, one of the issues here has been, even though it says tribal convictions, some defense attorneys went to court in different jurisdictions and said, oh, wait, well, we can't count a tribal conviction. If we have a tribal DV conviction, we really can't count that, because when that defendant was in tribal court, they didn't have the right to an attorney. And maybe they were railroaded, or maybe they didn't have the proper advice, and they had a tribal conviction. It's not right and not fair, and actually the statute mentions it. We're not going to count that tribal conviction because they didn't have an attorney representing them, or maybe they weren't entitled to it. Well, is a person in tribal court entitled under the U.S. Constitution to have an attorney appointed to represent them in tribal court? How many say yes? Okay, how many say no? Okay. Does the U.S. Constitution apply to an Indian tribe? No. Okay. There weren't tribal representatives in Philadelphia or wherever they were, coming up with the U.S. Constitution. The Constitution doesn't apply to an Indian tribe. Now, Congress passed ICRA, the Indian Civil Rights Act, which said tribes have to provide certain things, certain constitutional protections to people who are being prosecuted. The right to counsel is not one of them, okay? And you can have an attorney, but the tribe does not have to pay for it. Now, some tribes do that anyway, but they're not required to under federal law. Now, ICRA has been amended. This is another thing a lot of people don't know about. ICRA was amended to say if you're going to impose a felony crime, somebody faces more than a year imprisonment, or if a non-Indian is charged with one of these DV cases, the tribe has to provide them counsel, okay? So we have a case here involving Mr. Kavanaugh. And what this boils down to is Mr. Kavanaugh committed a domestic violence offense. He had some priors. The question was, one of those priors was a tribal DV case where he had no attorney appointed by the tribe. And the defense attorney was saying, we can't count that. And the Eighth Circuit said, well, yes, we can. We're going to be able to count that because we're not going to kick out that prosecution from the tribal court has been being invalid because the tribe wasn't required to give free counsel to a defendant. That also came up in the Supreme Court in this case. A lot of people don't know about this case involving Michael Bryant. Same result. Charge under 117. The Supreme Court said ICRA governs tribal court proceedings, only requires a lawyer to be appointed for criminal defendants who are sentenced to more than a year. That wasn't the case there. We're going to count that prior tribal DV conviction towards one of the predicate convictions under 1117. And so that stood up. Same thing happened in this Eighth Circuit case when we had a defendant, he used a firearm in connection with a crime of violence. They were trying to argue that the tribal court previous conviction couldn't be counted. In that case, the court said, even though the statute, and this is possession of a gun, not necessarily a third strike type of case. This is possession of a gun with a prior misdemeanor conviction. Even though 922G9 says has to be convicted in a court of misdemeanor crime of domestic violence, where an attorney has been appointed, the Eighth Circuit, relying upon that Supreme Court's case, said, well, tribes aren't required to provide counsel for that domestic violence previous conviction. So it's going to stand. So that came up. Okay, let's talk about, real quickly, some cases of recent interest. The Supreme Court and 10th Circuit, and then we've got a couple of other districts. This is an interesting case. This has to do with seizure, a search and seizure. And this basically involved a guy who had a motorcycle and it was stolen. It was under a tarp. The police went out and looked under the tarp. Can you go on someone else's property without a search warrant and look under a tarp for a motorcycle or stolen property? The court said, no, you can't do that. If it's in the curtilage or area of control of the homeowner, that's going to be an invalid search. In Gamble, it's interesting. We all know about double jeopardy, and that's not the game show. Double jeopardy means two different sovereigns can prosecute somebody for the same offense. Well, the question of whether or not that rule should still be in place is now pending before the Supreme Court. And this involves a federal conviction and a state conviction. And the defendant here is trying to get the Supreme Court to do away with this separate sovereign double jeopardy concept. Whether or not that's going to succeed or not remains to be seen. That's the case that's been argued. That's now pending. Madison versus Alabama is another case. And we haven't had any Indian criminal cases in the Supreme Court, but these would apply to some of our federal court cases. This is an interesting case that, if somebody doesn't remember what they did in committing the crime, they can still be subject to the death penalty. However, if they have dementia or they don't understand the basis for why the state is trying to execute them, then that can undo or stay the execution. Another case here involves definition of a burglary, and that might not seem like it's a big case, but again, this is another one of our 3 strikes cases. If you have 3 violent crimes or 3 drug offenses federally under what's called a under the Armed Career Criminal Act, 924C, you can get a mandatory minimum of 15 years. And the question here was if we had a trailer that was no longer movable, is a movable trailer a vehicle or is it a residence? And in this case, the court said it's a residence, therefore the mandatory minimum did apply. I'm going to skip over that one and get to our last 2 cases because we're running out of time here. You can take a look at them and fully explain. Okay, this is the case I think that was mentioned in the prior presentation, Comanche Nation versus Zinke. This was a case that was decided in the Western District of Oklahoma, went up to the 10th Circuit. Comanche Nation was trying to enjoin the Chickasaw Nation from taking a piece of land into trust or into for use as a casino. It was a competing commercial area, not too far, I think 45 miles away from the Comanche Casino. And in this case, the District Court and the 10th Circuit said there was not a problem with the BIA taking the land into trust. Either was a reservation, if the Chickasaw Nation was characterized as a Creek Nation under the Murphy theory, although the court said, we haven't even gone there yet, or if it was within the former reservation boundaries of the Chickasaw Nation, which it was. There's a cert petition filed with the Supreme Court right now on that case. This is a case that came out of the Eastern District. We had a defendant who was embezzling money, and this is an Indian country case, embezzling money from an Indian tribe who had PTSD and was trying to use a duress argument, saying that she was under duress because she was being subjected to sexual abuse by an individual, and that was basically a defense. The court said, no, that's not the case. We look at duress not from somebody who's affected by PTSD, but just the average person. Okay, the Indian Arts and Crafts Act is a federal law controlling federal regulation of who can be characterized as an Indian artisan. The federal law has 3 definitions. Federal law has a tribal member who's a member of a federally recognized tribe, an Indian artisan who's been certified by the tribe, or a state recognized tribal member. Some of you may know that the state of Oklahoma passed a similar law, but the similar law passed by the state of Oklahoma only allowed members of a federally recognized tribe to be categorized as an Indian who can advertise their goods as Indian art. What happened in this case is there was a lady, Ms. Fontenot, who claimed to be Cherokee originally. She went to the, I don't know how to pronounce it, the Powhatan. I think it's supposed to be kind of what the original, the Potomac tribe in Virginia, got enrolled with that tribe, which is a state-recognized tribe, and then brought suit against the state of Oklahoma saying, your state law that criminalizes somebody selling goods as Indian produced just because, or has to be a tribal member of a federally recognized tribe, but that's wrong. I'm not a federally recognized tribal member. I'm a member of a state tribe. Why can't I sell my goods as Indian owned as well? So what happened in that case was one of our new district judges, Judge Goodwin in the Western District, looked at the federal law, said there's 3 definitions of Indian, looked at the state law, there's only 1 definition, and said under the Federal Supremacy Clause, the state law is more restrictive than the federal law, and it conflicts with the federal law, so we're going to throw it out. So that case, I don't know if it's going to be appealed as of yet. That just the decision came down in March. But the state law basically is unenforceable now criminally. as a result of that. Now, here's a little snippet here. Those of you that have been to Las Vegas may not know that there's an entertainer out there that claims to be a member of this tribe. I think actually is a member of this tribe. When they were recognized by the state, he was there, and of course that was Wayne Newton, who is claimed to be Indian and a member of this tribe. So that's the conclusion. I think I have a minute left, maybe. If there are any questions, I will stick around for a little bit. Does anybody have a question of import? Like I said, there's a lot of material here. I did want you to take a look at these things. I do, unfortunately, give out my cell phone number, which is on the last slide of this presentation. So if you have any questions that you want to talk about, please feel free to contact me. And thanks to the Creek Nation and the Bar Association for allowing me to present to you this afternoon. Thank you.